And at this time, it's my pleasure to turn it over to Judith Grimaldi. Judith, thank you so much for being here today. Rachel, thank you for all your help coordinating this. And at this time, I'll turn it over to you guys.
Thank you so much. So I'm Judy Grimaldi, and I'm so pleased to be part of this webinar series that our law firm of Grimaldi & Young has put together for the Circle of Care PSS. As you can see from my tagline, I'm an attorney. I'm also what's called a certified elder law attorney. So I've taken the trouble to say I'm going to work specifically on the needs of older people from their retirement years to the end of their life. And so I've kind of focused myself. And I'm also a social worker. I have an MSW, so I try to bring that social service side to my work. So today we're going to talk about spring cleaning. Remember the day when your mom would say, let's get out, it's spring, we have to clean everything up. So today we're going to get our legal house in order. We're doing spring cleaning. And you might say, why? So next slide, please. Okay, so estate planning is really, although I'm saying it's time to get our legal house in order today, it's really a lifetime process. You really have to do it all the time. And people might say, well, why do I have to do estate planning? What's that all about? So most of my clients come to me and say they want to do it because they want to make sure they pay the least amount of state and federal taxes. So that could be your focus, tax planning. In this day and age, our estate tax rules are pretty liberal and pretty generous, and that's not the biggest boogeyman in our life. The next one, protecting our assets in the face of catastrophic healthcare costs. And the Circle of Care focuses on that very, very often about how do I get my long-term care needs met? How do I make sure that they don't completely wipe out my financial resources? We'll talk about, planning in terms of catastrophic healthcare costs that in the later years often occurs. And then the final is, I want to make sure I take care of my family to ensure that the intended beneficiaries, the people that I love and care about, inherit my assets and not others, or not just the taxman. So those are the reasons most people come to me for tax planning, and estate planning, for taxes, for fear about the long-term care costs. So what makes up estate planning? And what is it actually? It's transition, taking your assets, and your assets could be your personal stuff. And I have found, especially we women, we worry about who's going to get my jewelry, who's going to get that, the china I collected, who's going to make sure that the painting on the wall gets to the right people. It often deals with real estate, which is the house that we've been living in, that you brought your family up in, and of course your money. My son said to me the other day, Mom, that stuff in the china closet? Make sure you deal with it because I don't want it. And you'll find that is an issue, getting rid of your stuff. And stuff could be, things that are precious, really, definitely your home and definitely your money. So it's organizing what you have and then making sure it passes to the right people that you care about. Next. Tools. What are some of the tools that you need for estate planning? And you're going to hear a bit about today about wills and trusts. So we are going to be dealing with this. And in dealing with it, one of the key things that you have to worry about is who will do this for you. I'm not going to be here after I pass. Who will be my executor? Who will be my trustee? And do I have anyone who has special needs? So those are the kind of things that will be on the table today to talk about. Next. I'm going to just step away for 1 minute because I'm going to close my door so you don't get the background noise. Sorry. I'm back. Okay. So estate planning, as we talked about, because there are special people in our life, we definitely want to worry about our own aging. Both for ourselves and our parents, what would happen if when we pass, and what would happen if there was a disability. We want to be able to plan for if we have minor children or disabled children, and we want to make sure that that the most of our estate gets to our family, and we eliminate as much estate or income taxes as we can. Next. Okay, so there's some tools that you might realize um, have estate planning elements to it that you never thought about. So let's talk about some of those. If you have accounts that are joint with your daughter. I know often my clients will say, well, I put my daughter's name on my checking account and savings account because she lives around the block, and when I need it, she can do some banking for me, or she can help me out with some of those things. And that joint ownership was for convenience. But I want you to be aware that joint ownership also endows that asset with the ability to pass to the next generation. So whoever you name as your joint owner on your bank account or whatever, if you have a joint ownership, you've said you also are an owner. So if I should pass, the remaining owner, the joint owner, would receive this asset. And sometimes that causes a little bit of family distress because you didn't really mean for all your assets to go to the daughter who lived around the block because she's so helpful. You really wanted to share it. So examine your joint ownerships. And if they're for convenience only, you really need to identify that. Another tool that we will be talking about is the power of attorney, because those of us who are aging in place successfully and happily, I often have to think about, as we get into our really older years, we might need someone to step up to be our representative, and a power of attorney would do that. We also want to learn about revocable trust because so many of us have heard about trusts. In fact, I tease, when you walk off the plane to go to Florida, they almost hand you a trust. Everybody has a trust. But in New York, it's been a little bit slower. People are not doing trusts as much, but they're becoming more and more popular. We also need to worry about who's going to step up for us if we have a medical emergency. And that would be to assign the healthcare representation. And it's in New York, it's called a healthcare proxy. And we also recognize that in the healthcare proxy, there are limitations about who can see our medical records. We all have heard about HIPAA or HIPAA release. Those are the federal laws that say no one can see your medical records without your permission. Well, the healthcare agent needs to see your medical records to be able to make good medical decisions. So a HIPAA release is another tool that we will be talking about. The living will is another tool for health decision making, and that's a tool that would allow someone to make end of life decision. Some of my clients teasingly say, well, that's the pull the plug document. Well, not exactly. It could be to enhance your care and make decisions about end of life, but it could also be a decision to withdraw treatment. And then the final is disposition of your remains and the ability to make sure that your final remains get handled, whether it's a burial or a cremation. So these are the kinds of tools that we're going to make sure you have in your hand and you understand their use next. Okay. The other terms that we're going to go over is what's a will and what are the elements of a will, what's probate, how do you handle probate, whether a trust is really necessary, what do you do with real property. So these are in taxes. So those are our categories for today. And that's why we needed till 2:30 to go over all of this. Next slide. Okay, so the two basic first steps that everyone should take in order to get their legal house in order are two first basic documents. And I mentioned them a little bit before, but I'm going to go into them with greater depth right now. And that's the healthcare proxy is for me, the number one. If someone could make medical decisions for me if I was unable, it would be very, very important to me. So I think I'm capable, I think I'm alert, I think I'm far from being incapacitated, but yet I found it important and useful to know that I've appointed an agent. And so I've appointed my two sons. And in fact, several years ago, as I was leaving my office, I tripped and kind of damaged my knee, and I really couldn't walk. So they brought me immediately to the hospital down the street, and it wasn't a very good hospital. In fact, Rachel, who lives in my community, knows it's closed now. That's how bad it was. And when I was there, I said, I don't want to have surgery here. They would say, you need, arthroscopic surgery on your knee now, blah, 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 blah. I said, I don't want surgery in this hospital. I remembered I had a healthcare proxy. I said, and I was in pain. I was stuck in a bed, and I was pretty feisty, but I couldn't really get get out there and make those, active decisions for myself. But my agent, my 21-year-old son at the time, James, was able to do that for me. So it's not always end of life serious. It could be quality of life decisions. So I could get my surgery done at Hospital of Joint Diseases, where there were very, very competent doctors. So I'm telling you that story, that the healthcare proxy is not, could be a very practical, useful tool, even when you're perfectly capable, but not really that functioning that well. So healthcare proxy is a New York State document, and it's something that I think everyone should have. Even those of you who may have children who are going off to college, the caretaker generation, they should have them, because once I've had a family who said, my son was off at college, he was over 18, he injured himself at college. I called the college to find out how he was doing. They wouldn't tell me because of privacy rules. He was an adult. And they said, well, you'll take my check for tuition, but you won't tell me if my son is injured. So it can be a very practical document for serious end of life choices, as well as day-to-day kind of medical decision-making. So it's for adults, and everyone should have one. The second document is the power of attorney. And that is about legal and financial. So New York separates health from money. So there are two different separate documents. You could have different separate people, actually, but both of them appoint a representative to handle your affairs. One is the medical decision-making, and the other is the legal and financial. And they will take effect when you become incapacitated. Next. So let's talk a little bit about the power of attorney. So it's called, and you may hear this term, durable power of attorney. What does that mean, durable? It means if you sign it today when you're perfectly capable and you become incapacitated, incapable, unable, that it will endure and continue even when you're unable to direct your agent. It can handle any money and property. So from your home to your bank accounts, to your 401k, to your life insurance policy, anything legal or financial. It can manage real estate. And it could be used to protect your assets. So for example, if I sadly had a medical emergency where I thought maybe I needed to protect my assets, my agent under the power of attorney could move my assets around and do Medicaid planning. They could handle any of my insurance payments. They could pay my taxes. So it's a one-stop shopping for all your legal needs, and you invest that power in someone else to be able to become your legal clone. Next. So it is, because it's so powerful, New York has created a very special and strict document. So I caution you, if you're saying, well, I'm going to pull one off the internet. LegalZoom has a great power of attorney. Or maybe I'm going to buy one in Staples and just have, fill it out, and we'll go to the local drugstore and they'll notarize it and it'll be fine. And it might be fine. It might be perfect, actually, but it might not be. And you won't know it's not fine until the day your appointed agent goes to use it because you're incapacitated and there's no do-overs. You can't do it over, it's wrong. So I really think that you should always, if you're going to do this document, you should have the help of a professional, whether it's an attorney or someone who really has experience in doing these. Because, as I said, there's no do-over. And the banks are very strict. They'll only take a New York statutory form. So New York went through the trouble of creating a special form, and it has to have special gifting language in it. And it even when you're alert, like I am today, and I have a power of attorney, I can tell my agent what to do. But if I'm unable, the agent has free capacity to continue to do it. It ends when you end. So it's an agency, and you can't be an agent of someone who's not here. So the power of attorney is very powerful, and you really should get legal counsel when you're executing it, and don't rely on just LegalZoom. Next. Okay. So New York has a statutory standardized form. I strongly advise you to use it. It's effective as soon as you sign it. It must be signed before a notary public. And people might say, well, my mother can't sign anymore. She can't sign. It's not the signing part. It's not the signature or the quality of the signature. It's this. Does she understand? So if she understands and only can make an X, it is sufficient. And it will eliminate the need for guardianship. Now, someone in the chat asked about a springing power of attorney. And there is such a thing as a springing power of attorney, and that means that it's you sign it, but it doesn't spring into action or become effective until a certain condition happens, like my 65th birthday, or when two doctors say that I'm incapacitated. I've refrained from doing springing power of attorney, although I see the wisdom of it, and that's because often I've had doctors who refuse to make that decision about my patient is no longer has capacity. They don't want to be involved in that legal decision. And we've had difficulty getting them to spring. So New York, in essence, does not have a standard springing power of attorney. They also have found it to be complex and often troublesome, but you can put springing language into your power of attorney as a modification, but it's not usually used because of the inability sometimes to affect them. Next slide. Healthcare proxy. That's the second of the two simplified documents. And then we talked, it's the medical decision maker in the event of, this one is springing. So those of you who are more cautious, it will only spring into action when a doctor determines that you're unable. So there's that safety measure if you need to have it. But it can cover all decisions, as I told you about my knee, to the very serious end of life. So if you have these, this does not need a notary signature. It only needs 2 witnesses. And often you're presented with a healthcare proxy as part of almost every admission into a hospital. They'll put it as part of your admission package. Hospitals are very anxious to see that everybody has this document. Next slide, please. Okay, there's another document that you may hear about. It's not as commonly used, and I wouldn't put it as my absolute you must do. And they're called medical orders for life-sustaining treatment. They've come out of the confusion that people have had about end-of-life choices and the seriousness of end-of-life choices. Often a living will, which says generically, I don't want to be resuscitated, sets out your decision, but it doesn't have the strength of an order. This is a doctor order. This is one that specifically the doctor has had a conversation with you and puts an order in your file that says, if this to forego specific treatment. It could be, I do not wish to be hospitalized. It could be, I do not want a feeding tube, or I do not want to be intubated, or I don't want to be resuscitated. It must be signed by a physician, and it only is good for 1 year because things could change, it could improve. So this is an order that this is not done routinely. I, as an attorney, couldn't do this order. I could suggest it, I could prepare it, but it must be signed by a doctor because it has the weight of a medical order. Next slide. The living will. This document, I don't know if it can be moved up a little bit, but so a living will is, New York does not have a statutory living will. Remember I said there's a statutory power of attorney, you should use New York's form. There's a New York healthcare proxy. There is no New York living will, but New York recognizes your ability to set out your decision. So it doesn't appoint anybody, it just describes your philosophy about end of life. And end of life in this kind of a document is when there's no hope of recovery, that there's no treatment that you're going to benefit from. There's nothing that a doctor has said that any treatment would be considered futile. So it addresses mainly the use of artificial or mechanical means, and it does focus on providing some pain relief or relief from stress, and it doesn't need a notary, but it does need 2 witnesses. So it's the will or the last will that relates to my medical needs, whereas a last will and testament relates to money. So again, New York keeps bifurcating or separating out medical from money. So a living will, I agree you should have. It doesn't have the same weight and power of a healthcare agent, which is a person who could mix in and listen to what the doctor says and weigh decisions and parse out decisions, where living will just sets out a philosophy. It's on the books, kind of, so that if a doctor is looking for direction or a family member is looking for direction, I've often seen this used by a family member who says, I have this hard decision what to do with my mother. Should I continue treatment? Should I do chemotherapy? Should I make sure, do extraordinary means? And the living will, which is signed by mother, it helped them say, my mother's given me direction. It's not all on my shoulders. I have now a roadmap of what she would want in this situation. The decision still has to be made by the agent, but it's like a direction. And that's very, very helpful and can ease this very hard choice that someone might have to make. So next slide. Guardianship. When you have failed to do a power of attorney, a healthcare proxy, any medical directions, and there's no appointed agents to make decisions for you, and you're not in a hospital setting, you're out in the community, who's going to make things happen for you? Who's going to move things along? Who's going to keep the ball rolling? Who's going to pay your bills? No one has the authority to do so. So the only recourse a family member might have is to go to court and have a guardian appointed. As I've done guardianships many, many times, I dread them because it's such an impersonal, legalistic way to solve personal and family problems or financial problems. It would be so much better to have an agent. So I hope that you'll take this as a strong caution that these legal documents I mentioned before could avoid this terrible ordeal of going through a court-appointed guardianship. And often their family can't agree who should be the guardian, so the court appoints someone from their roster. And often they're the judge's cronies, or a lawyer who needs extra work, or a social worker with a good heart but maybe doesn't have legal skills. And it often takes a lot of time and energy and expense to get through guardianship. And the guardianship doesn't then just on their own. They have to continue to report back to the court, to put in annual reports. There's strict supervision of their action, which you might say, that's good, Judy. We want a watchdog on these guardians. But all of that, cha-ching, costs money. If you're in a hospital setting, though, the hospital, a law was passed several years ago called the Family Health Care Decision-Making Act, which allows the hospital only, it doesn't handle banks and finances and 401ks, but at least medical decisions can be made internally within the hospital setting by doctors and or a surrogate who comes from a list. There's a list within the law that says the first surrogate, even if they didn't get around to it, would be the spouse. If not the spouse, the children. If not the children, the brothers and sisters. If not the brothers and sisters, other family members. It goes all the way down to neighbor. So it's really an effort on the part of the medical provider to be able to have someone make decisions without needing a court. But for other serious medical and financial issues, your only recourse would be guardian. I see there's a question in the card. So there's a question I'll get to that about co-executors agreeing to co-jointly work on mother's care. So I'll talk about that in a little bit, or I'll have to answer it in an email to you, Spru. Okay, so guardianship is a necessary evil when there's no direction in place or the person has no appointed agents. But I hope that it could be avoided by some good planning in advance. Next slide. New York has this very special law called the appointment of an agent to control disposition of remains. And you might say, oh my God, Judy, why do we have to have a law about that, getting people buried? I'll tell you the backstory and maybe you'll understand, but it can be very useful. This law can be very useful. The backstory is, sadly, when there were soldiers coming back from Iraq, often not alive, and families were going to claim the bodies. The mother and father, who were the primary representatives or the closest next of kin, were no longer married. So we had a divorced couple who went to claim their son's body, and they didn't agree about where it should go. And there were arguments on the tarmac. So New York State said, this is not okay. So they passed a law that you could create an agent just for the purpose of determining how your remains should be handled. I'm sure it was, and they would have made sure the soldiers going off to war would fill these out. I'm sure it was not an upbeat moment for a soldier to say, okay, I'm shipping out and I have to tell somebody where to bury me. But for me, it has turned out to be a boon when there is dissension in the family, when there's, second marriages, the children and the spouse. So you can set out who should make decisions about there have been fights about this, sadly, and it's a time of stress within the family. Probably if it was done in a calm, orderly way by the decedent before they pass, there would be no need for this. You can put in special instructions, you can provide for anatomical gifts. It again should be signed by you, the principal, and 2 witnesses. And it can eliminate some family battles that have been disruptive at a time when family is under enough stress as it is. So we've been using these pretty commonly, even though sometimes it's as routine as possible. I'll give you I always like to give personal examples to kind of diffuse some of what you say, oh, this isn't necessary. I have 7 brothers and sisters. So can you imagine trying to corral 7 people's opinions when my wonderful 94-year-old mother passed? It was so much easier. I was in charge. I wasn't going to dismiss their opinions, but I didn't have to hold up to get everything done. And she told me what she wanted. Surprisingly, my very religious mother wanted to be cremated. So there it was. We're in black and white, and there were no questions, no disruptions, and it really made things much smoother. So consider this document. Next. Okay, so now we're going to move into, so those are the basic documents you should execute in life. What about the documents that handle when I pass? What do I need? So before we talk about wills and trusts and that, I just want you to understand that what probate is, because that seems to be a big boogeyman that makes people say, I have to avoid probate. Probate is like a devil out there. And in New York, probate, it wasn't so complicated, but post-COVID, it has become a very delayed and complicated process. I used to say it would take 2 months to get through probate. Now I'm saying it takes a year, and I can't even guarantee a year. So avoiding probate in our state, and if you have multiple states, is really important. Any asset that is governed by a will. So you write a will and it says, my house goes here, my jewelry goes here, my bank accounts go here, to create a trust for my grandchildren, whatever your will says. It is an instruction manual that has no power and effect until it's presented to a court called the surrogate court. The surrogate judge in Norris County, where I live in Brooklyn, there's some wonderful surrogates, and they review the will to make sure it's not a forgery. Poor Brooke Astor, one of the richest women in New York City, had a forged will. Her son forged a will. So the first job, is it a proper will? Is it properly executed? Are there witnesses? It's not forged. Does everybody agree that it's a good will? The judge then would sanction that will and appoint to the executor. Once the executor is appointed by the court, they can go and collect the assets, pay the debts, pull the monies together, divide them as the will instructs them. That's what probate is. It's a court supervised process of transferring money from one generation to the next. And that could take as long as the court, if the court's backed up, as it was during COVID, because we had 8,000 deaths in Kings County, got a little slow. And it took 2 years to get through probate. Now it's down to about 9 months. So people say, how can I make my assets non-probatable or not have to go through probate? And so the method of doing that is when you name a beneficiary on an asset, like a life insurance policy generally always has a beneficiary, or a 401k or an IRA has a beneficiary, or annuity has a beneficiary. So if you name beneficiaries or transfer on death designation, those are not governed by the will and will go straight to the people you named, which could be wonderful, But it could be, in my family situation with 7 brothers and sisters, it could be really messy. How do you make sure all 7 get equal shares? So a will would be a better way to do it. So you have to weigh the pros and cons. But probate assets are governed by a will, goes through court. Non-probate assets, you designate who you want it to go to in your document, in your when you open the account, and it doesn't go through the court supervision. I think next slide, and I think we have 2 questions and 1 chat. So I'm going to look at the questions for a minute. The one question was that does the disposition of burial remains from New York State, can you put in religious observances or religious rules into the document? Absolutely. Whatever special instructions you want to put into it, all the more reason for you to do this document, because the sun rules are very special. In the Jewish religion, you have to bury within 1 day. And in this question, they say they have to hold the body for at least 4 days. So those special instructions would be well suited to be put into this document. That's the best way to handle it. You could put the instructions in a will, but frankly, as I just told you, a will can go through probate for 9 months. So that is kind of a long time to wait for the disposition of burial remains. So it's much better in this document. And then the second question was, are handwritten, not witnessed or notarized documents considered valid? Handwritten, that's fine. But if they're not witnessed and they're not notarized, then no one knows whether it's not validated. Then you might say, well, we could do a handwriting analysis. So that sometimes handwritten wills are given a little bit more leeway if they don't follow all the rules, but there has to be a witness for a will. That's the New York State rule. Maybe other states have different rules, and a power of attorney must be notarized. Okay. So we talked about probate already. That is any assets held in your name with no beneficiaries. I think we can skip this slide, Rachel. So what happens if there is no will? There's nothing. I put a few beneficiaries on my bank accounts, but everything else is just sitting there with my name on it. My house, the deed is only in my name. What happens? Many people say, oh, does everything go to the state? No. New York does not like messes. New York does not want to be the landlord of your house. They do not want your home. They don't want the money, so they have rules on the books. New York State and many states, almost all states, have what's called intestacy. So that means without a testament. We lawyers love to have Latin words. So testament, testacy, and in means not. So there was no testament. So what do we have? The state said, well, we'll just make up our own distribution plan. And the distribution plan follows strict family lines. So you do a family tree, who are the next of kin. And so, for example, if I died as a single person with no children, all of my assets upon my death would go to my parents. Now, more than likely, my parents are not alive, and they're not. So what happens? There's no parents. So then it goes up the next generation to my grandparents. Well, if my parents are dead, probably my grandparents are dead. So what happens next? Then it goes to the children of my grandparents. So my parents, brothers and sisters become my next of kin. Well, they're pretty dead too. So then if my aunts and uncles are dead, who is next? My cousins. So it goes out to across the family tree and down. So again, it might be wonderful that they're my family, but I haven't seen my cousins in Oshkosh in the last 30 years, and I would not be thrilled that my estate would go to my cousins in Oshkosh. I have very dear friends right here in New York. I have charities I care about. So if you are silent by not giving a will or a trust and there's no direction, the state will allow families, the family tree to operate and distribute among bloodlines of the deceased person. What happens often is there was one cousin that was really close to you, but she's not going to be treated the same as the Oshkosh cousins. So disruptions of family disputes may occur. Finding those family members in Oshkosh cause, you have to find genealogists and legal and administrative costs. So that causes delay. If I did have children, but my children are minors and they can't represent themselves because they're under the age of 21 or 18 in New York State, then guardians ad litem would have to be appointed. And while they're waiting for support, because I'm no longer here to support them, the delay in courts could create great strain for them. So without a will, it'll happen. The estate will process. It will take longer. It will cost more. It might go to people you didn't care about because they're not in the right bloodlines. So it really behooves you to do a will, especially if they're a dependent minor or disabled heirs who are really dependent on your money for their support. So please think about having a will or doing those joint or beneficiary designations so that your assets do go to the proper people. If there is multiple states, you have a house here and a little cottage in the Poconos or an apartment down in Florida or on the Jersey Shore or something, and you're in 2 different states, it means 2 different probates, 2 different administrations. So all the more reason to consolidate under a will. You give some good instructions. Next slide, and I'm going to look at what the chat has to say. It's the same one about co-administrators. Okay. So just to remind you, as we said, a will passes, but there are assets that pass outside. So we talked about joint accounts already, or when you put joint tenants with right of survivorship, that's what JTWROS says. You might see a deed that has that. Assets in a trust, generally life insurance policies, life estates for real property. All of those are non-probate assets. They're not governed by a will. So if you wrote a will, many of my clients will come in, I have a will and it says it's divided equally among all my children. That's what I want. And then I look at their asset list and their life insurance policy is going to their son because she's going to take care of the burial. And the annuities is going to the grandchildren. And the retirement account is going to somebody else. And they put their daughter's name on the house because she lives upstairs. And so the will says, even Stephen among all my children, but the designations that she's done individually go very differently. That's where disputes have happened. And it's not inappropriate to do designations, but that the totality of your estate plan should take in all of this and really look at it. Am I being fair if I give this to one? Am I equalizing it? Can we equalize it within the will? So that's where the planning comes in. A will is, when I see those ads, come and do an $100 will, simple will. For me, a will could be simple, divided equally among my children, but it's the planning underneath the will of understanding what the assets are, how they're being administered, what is your intent for each asset, makes the will the plan more complex. The will still might be simple, but does the will align with your real plan? That's the question. Next slide. Next slide, we did this. I guess it's some slides are repeated here. Okay, things to consider when you're doing a will. Of course, who gets what? What are the percentages? We tend to use percentages. Sometimes families want to put dollar amounts down. They want to say, I want to give 50,000 to my grandchildren. I want to do this. I want to do that. And then, like my mother, they lived to age 96 and used up a fair amount of the money. And when she made her will at 80 and what she had at 96 was completely different. So I think of it like a pie. So if the pie shrinks, then it becomes a tart. If you use percentages, everybody's percentage shrinks as the pie shrinks. If you use dollar amounts, it's possible that in my mother's case, if she had done, she had 19 grandchildren, she had given all the grandchildren a specific amount of money, and then the rest gets divided among her children. There wasn't enough money to give this specific bequests, and the children probably would have gotten nothing. So it could be dangerous to give specific amounts. The beauty of specific amounts is flat. They can't ask questions. They can't say, well, how did you get to that number? $5,000 is $5,000. But percentages do work better, and that's how you should be thinking. the other thing is anyone in the group have a disability? So I had a client who said, my father left me an inheritance, but it was like a stick in the eye because it didn't do me any good. It wasn't enough money to solve my problem, but it made me lose all of my benefits. He was on, he was on Social Security disability. He was on Medicaid. He had food stamps, and this influx of a windfall of an inheritance may put him over the asset and income levels, and therefore he was unable to continue. But it wasn't enough money to solve that problem. It didn't replace the loss of benefits. So if you have disabled children or disabled heirs or people with spendthrift problems, gambling problems, some limitation that makes the influx of money be a danger or a hindrance, you really need to do a special trust. You can still give them money, but you encapsulate it inside your will that says, all that I have goes to my 3 children, except the share that goes to my disabled son shall be held in a further trust for his benefit to be run by his sisters so that he doesn't lose his benefits. And the other thing is there's also the sweetheart will. I give everything to my spouse. With tax consideration, giving everything to your spouse may cause that surviving spouse to have a tax consequence. So you really have to examine the impact of it on the surviving spouse. The question was in the chat, who should be the executor or manager? And that's all an executor is. They don't get more money, well, they could get executor commissions, but they're the managers of the estate. They have to pull the money together. They have to make the debts. They have to make peace in the family. They have to distribute the property. They have to clean out the apartment. There's a lot of work to be done. So you pick that person by their skills, their energy, and their ability to attend to detail. I'm Italian American, and often the oldest son is, the prince, and the oldest son should be my executor. But often the oldest son, being a prince his whole life, is not used to doing a lot of work or a lot of detail work. He's just getting other people to do this detail work. So often they maybe not be suitable, or you need to pair them with a worker bee. So who you pick for your executor is very important. Think of it as a job, not as an honor. It is an honor because you trust them and you hope that they'll do everything that's proper for the benefit of your family, but it is pure, some of it's just pure work. So make sure they're capable of just digging down and getting work done. And that's often when executors criticize, is because not because they're stealing or doing anything improper, it's that they're doing nothing. They're not moving the process along, and it's a tedious process. The question that was in the chat is, what if I had a co-executor? What if my brother and I are co-executor? How do we manage that? And it's commonplace for it to be executor, but they should get along. So that's the second question. I'm going to make my son and daughter be my executor, or I'm going to make my best friend and my accountant be my executors. Do they get along? Do they have the same value system? Are they going to be arguing about, what should be done first, or what should be done with this or that? They should have the same kind of ability, a cooperative spirit. And you should always have secondary. You shouldn't just say, I'm naming one person. You should have, if not this person, then this. If not this person, then this. Both alternate beneficiaries and alternate executive. We are living a long time. We're living well into our 80s and 90s, and things can change. And sometimes you don't go back and fix although you should check out your estate plan regularly, or when things change, but sometimes we don't. So alternates make it possible you're not to have to do the document over and over again. Okay, next slide. Someone had asked a question, can I do a deed in lieu for my home and rental property to my children where they inherit them automatically after I pass? So we're going to get to that, I promise. Okay. So the benefits of having a will is you can name guardians if you have underage children. You can make charitable bequests to charities, which are 100% tax deductible for estate planning purposes, and you can't do those with named beneficiaries. Next. Just remember that wills are revocable documents, so that it's not locked in stone. I often have family members come in as a group, and the son will say, I'm the executor of my mother's will, as if he's like in charge of everything. A will can be changed. I have clients who give me a living changing their wills regularly. I try to discourage it and see if I can get them to kind of settle in on their decision, but wills can be changed. In fact, the first line of every will is, this is my last will and testament, and I revoke all prior wills and testaments, like standard language in a will. What should you do once you've signed this will? Where should you put it? And most people say, oh, I'm going to put it in my safe deposit box at the bank. No, don't do that, because guess what? Safe deposit box gets sealed. Safe deposit boxes are not available on Saturday or Sunday, or any bank holiday for that matter. If you have the original in a safe deposit box, and they learn of the person's passing, they'll seal that box, and you can get the will, which you need to probate to start the whole ball rolling. So I recommend you keep it in your own home, buy a fireproof little safe or safe. Some attorneys will keep your will for you as a protective issue, especially if they feel there will be some will tampering. I don't keep wills because in the 25 years I've been doing this, I just ran out of space. So I've been encouraging people to take their property with them. And now that we have sometimes safer homes, you keep it in your own possession. Wills should always include some special consideration for minors and spouses. That's the real people you're responsible for their necessary, your children and your immediate family. And that's how wills should be focused. And so think about that. Who are those people? What are the needs of those people in drafting your will? And we do say that wills should be reviewed every 5 years, especially if there's a major change in your life. Next slide. Let's see what some of the questions are asking. If my healthcare proxy lives in another state, when she can come immediately to tend to my needs, if I need us, is there, oops, let me see if I can read the rest of this. Is there what? I don't know what the question is. People often ask me, does the executor, does the power of attorney, does the healthcare agent, do they need to like live near me? Is geography important? Well, geography is important because of convenience. You know, you like to have them by your side when you need them. But with the issuance of medias like Zoom, like we're on Zoom and we can see each other and talk to each other, faxes, online banking, the need for them to physically be in the same vicinity as you is not as strict. We have had powers of attorney who are across the country, in California, in Europe even. As long as they have an ability to communicate, and if push came to shove and you really needed them to be by your side, they care enough about you to be able to do that. That's most important. You do not need to be. Now, New York has one exception, and that's in order to be an executor, you have to be either you have to be a US citizen, or if you're not a US citizen, you have to have a co-executor who's in New York State. And that has to do with the court wanting to have jurisdiction over you. And if you're out of the country or even out of the state, it's a lot harder for the court to reach its long arm and control what you do. So that's it. So some of the terms that you might want to just be aware of, because we lawyers love to throw around this term, testator. What's a testator? If you harken back to Latin, you see the word testament in that. Testator is the person who wrote the will. So I write my own will, my last will and testament, I'm the testator. The executor is the person who's been appointed to be your manager when you die. When we talk about bequests, general, specific, wills give bequests. That's a gift. Fancy word for a gift. Who's going to receive inheritance or distributions from your estate? General inheritance or non-specific might be, I'm giving the specific bequest of my house to my daughter. Everything else is put in a pot and divided generally. The word devisee, and beneficiary are all the same. Is a person who receives an inheritance. A residuary beneficiary they say, when you pull the pot of money together, that's your estate. That's the residuary estate that isn't needed for taxes administration. What's the leftover? The leftover is the residuary. And if I'm sharing that residuary with my brothers and sisters, I'm a residuary beneficiary. And legacy is just another word for beneficiary. It's because I've written it in, I've made you my legal document, I've given you part of my legacy, you're a legacy. So these are the words that lawyers might throw around within the wills. And you just can, they're usually repetitive of the same thing. We just like to diversify what we call it. Next. Okay, next slide. I'm going to skip this one. Okay, so we talked about probate, and that's when the court reviews the will and says, good will, good job, good executor, go for it. When there is no executor and no will, it's called administration, which means I'm going to administer the estate, the same thing. I still need to appoint a person, but it's going to be according to bloodlines. So the personal representative who will make sure the will gets probated and moved along and processed is either the executor under a will or the administrator under when there is no will. But they both will pass according to the rules of the state. Next slide. Okay. So if there is no will, the court will sanction your estate representative. So if there's no will, anyone who has an interest in the estate, any child, any beneficiary, any legate person who is named in the court's, not the court, the law's family tree, can step up and say, I want to be the representative of this estate. So you could have dueling brothers and sisters. You could have, when I'm smarter than you, I want to be the administrator of you. So the family has to coalesce around one person who will step forward. At the end of the day, if there was dueling sisters who both want to be administrative, then the court would determine who gets to manage your asset, not you. So the benefit of doing a will is you get to pick who's in charge and how it gets distributed. Because there is no will and the person wasn't chosen by the decedent, the court will also require that whoever steps up to the plate and says, I'm going to do the job, has to be bonded. And a bond is an insurance policy that says if you screw it up and you don't administer the estate properly and you lose money, the insurance company will fill in the losses with insurance payments. So a bond can be expensive, and it could, some people are not bondable. Like if I had a bankruptcy proceeding in my past, no insurance company is going to insure me because I already have a history of making some bad financial decisions, or if I had a criminal record, or if I am just, have no financial background. The insurance companies might not bond me. So I will not be able to serve as the personal representative, even though I have my family's best interest at heart. The other thing is you have to prove your family tree. So you have to demonstrate that even though you say, I only have two brothers and here they are, I have to get outside source to verify that I only have two brothers. I could have just left one off. So the administration without a will often is more expensive, more time consuming, and a lot stricter in ministry. So that's why people want to avoid administration by either having a will or what we're going to talk about next, a trust. Next. I'm going to skip this one in the interest of time. Okay, what are some of the jobs of an executive? So when you're going to appoint someone, and I said they have to have skills, attention to detail, be smart and cooperative, these are the things they're required to do. They would have to file your final tax return, and they would have to make sure any state tax return. So let's say the estate takes 2 years and money is sitting there for 2 years. That's state money. It may generate taxes, need for taxes, so that your final income tax return, as well as any estate or fiduciary tax return, they have to collect all your assets, they have to find them. So, sometimes it's half detective work. I often say, look at the decedent's last filing of income tax. And if you look at all the 1099s, you'll probably or the W-2s, you'll see where they worked, where the assets were, because they generated a 1099. You have to pay your bills. You have to notify Social Security and the pension company. You have to make sure there's no collect any death benefits. You have to accumulate all the accounts, and then your family's watching, so you have to make sure you make timely distributions. So this is the job. It's real paperwork, accounting work, and you also have to be a kind of a diplomat in making sure that everything gets distributed properly, everybody understands, keep everybody up to date. Because when you're silent, often they think something's up. If you're not telling me what's going on, maybe something's wrong. So you have to be a good communicator. Next slide. I'll take the next slide, Rachel, if you can. Okay, so let's talk about the other tool. We talked about wills and probate. And in avoiding probate, we all know, if we watch Susie Orman or whatever those shows are on the television, why don't you think about a trust? And people say, I don't need a trust, that's for rich people. You know, well, more and more people are doing trusts. And so let's understand what it is. It's just a document. If you put it next to your will, it looks exactly the same as paper. And I think of it as an instruction manual. It says to the world that I'm putting all my assets under this instruction manual called trust. It tells everybody what to do. It appoints me, if I'm the grantor, the creator of this trust, I'm creating this trust. I might be the trustee, or I might appoint my oldest son as the trustee. And I'm telling the world, this is how it should be managed during my life, because it's a living trust. And this is what should happen to my money when I die. So it incorporates like kind of the power of attorney powers and the will powers in one document. So that's how it avoids probate, because it goes from life into death in a smooth transition of one document that governs the whole process. No need for court, no need for anyone to move assets from your own personal name into an estate. You've already moved it in life into this trust, therefore it just stays there to be administered. Most trusts end when you end. So the trustee role is still there, but the need to administer a trust ends, and their job is to distribute the assets. So trust could be a living trust, which is what I just described, or it could be a testamentary trust. Again, you see that fancy Latin word, testament? It's trust inside your will. So it could say all that I have in my will goes to my 3 children, but the 1/3 going to my son shall continue in a testamentary continuing trust for his benefit because he's disabled. And so it's a special needs trust. So a trust could be created while I'm alive, or a trust could be created out of my will at death. Both of them avoid probate because you've created this instruction manual that does not require a court proceeding. Those living trusts that we do could either be revocable, changeable, amendable, ripped up and start all over again trusts, or irrevocable, which means it's locked in stone, and once you sign it, it's a done deal. All trusts avoid probate, and that's their main criteria and benefit. It avoids having to go through that court proceeding. I think the real benefit is the living trust potential for managing your assets while you're alive. So I create a trust today, and I live to the ripe old age of 93, but at 93, my mobility is a little slower, and my mind is definitely slower, and my hearing's gone. So that's me at 93, and I might appreciate the management of my assets by my successor trustee even more than I appreciate avoiding probate. But that's me. So it has the benefit of management. It's smooth sailing for your estate with avoiding probate, and ease in which your bills can get paid, and your recipients of your estate will receive their money without court delays and court course. Next slide. So the other reason it could put in some other advantages of a trust, it could put in some very sophisticated tax planning. And we have a big question mark about estate tax. Right now, most of us don't worry about estate tax because the estate tax ceiling is over $12 million. And God bless you. I hope there's someone in this audience that have more than $12 million. But most people, most average person does not. But that law that's on the books right now is about to sunset, and it will sunset in 2025. And therefore, tax issues might change for some of us. It's going to go down to the 5 million mark, 5 million plus. And those of us who are fortunate enough to live in New York City and maybe own real estate, I don't know any homes in the city of New York that are less than $800,000. So it is kind of easy to get over $1 million when you have a house, bricks and mortar, that gets you pretty close. The other advantage of a trust is if you have out-of-state property, or because you would have to do probate in every single state that you own property, Florida, Pennsylvania, Massachusetts, wherever, and that means multiple courts and multiple probates and multiple costs. So you want to do trust if you have out-of-state documents. If you're treating your children or your heirs unequally, now you might say, well, I have the right to do that, and you absolutely do. You can, you can leave out people. You don't have to, and the only person you can't leave out easily without a violation of law is your spouse, but everyone else you can leave out. So if there's unequal treatment, it's open to criticism and what we call contested probates. But with a trust, there is no probate, so there's no place to contest it. And that kind of chills the decks or the possibility of will contests. The other thing is there's privacy. I don't know if you've noticed, every time there's a celebrity who dies, the next day their will's up on the in the front pages and the headlines of the entertainment section of the papers, or on some blog or posting. If you're in a trust situation, you never have to go through a court, so your will is not going to be probated, and there will be no. You'll have a natural privacy right. You don't have to display your will as a public document, and there's no delays. So those are the advantages of a trust. The disadvantages could be it costs more to do a trust than it does to do a will, because there's more to it. There's more drafting and more funding. So there's a more expensive proposition up front than a will, but there's less cost at the back end. So those are the pros and cons. Next. So most people ask for revocable trusts. They want to control their assets as long as they can. So a revocable trust, the grantor can also be the trustee. And you can name successor trustees for when you lose capacity in the later years or you pass, the successor trustee automatically steps up. You can, because it's revocable, you can change the trust, you can change the assets in and out, you can change who the beneficiaries are. It's a completely amendable, changeable, fixable document. What doesn't happen is, because it's still in your control and that's what you want, it is also an available asset. So creditors can invade a trust. Medicaid can invade a revocable trust. A revocable trust has no creditor protection or asset protection. So what you gain by having flexibility and control, you lose in that you don't have the creditor protection. So most people start off with a revocable trust in their early retirement years, and then in the later years, they sometimes convert their revocable trust to irrevocable in order to asset protection and Medicaid planning. Next. Next slide, please. And I'm going to take a drink of water. Yeah, irrevocable trusts, which we skip that slide, is what we use, yes. You give up control on an irrevocable trust. You cannot be your own trustee, but it still can be pulled back into your estate for tax purposes, but it can protect against liens, creditors, Medicaid, and that's what most people use when they want to move their assets for protection and they want to apply for Medicaid. And that's a whole nother seminar, and this series will have a whole session on Medicaid planning and asset protection. I think it's the last of the series, so come back for that and we'll get more details about an irrevocable trust for asset protection. Next slide. Okay, this is a special needs trust, and this is, remember I spoke a little bit about if you have a child who's disabled. So there is a trust that you can put inside your will for a disabled child, or you can do a freestanding trust. And many families who have a disabled child within their, and they're the caretaker parents, they worry, what's going to happen to my child if I should pass? How do I make sure that their quality of life is maintained? They want to put a source of money aside, separate and discrete from their other estate plan, to make sure that the child is always has this safety net under them. But they recognize if they just give the money to them outright, they'll lose their Medicaid and their SSI and some of the benefits that they need to rely on. So the state of New York and the federal government have created this category of special needs trust that says money put into this trust for this benefit is exempt from being considered an available asset for Medicaid, but can be used to enhance the disabled person's quality of life. And so it's something that you really should consider if you have that child. And many of us with grandchildren often have seen that our grandchildren have been diagnosed with autism or learning disabilities. These special needs trusts could be eligible for them. Sometimes families say, I wish I could do a trust like this. I have no money though. I need the money for myself first. And if there's leftovers at death, I'll be happy to create a special needs trust. Some families who have that concern will do this freestanding special needs trust and then fund it with a life insurance policy, so that they don't have the money to put in it right now. They fund it with very, very little just to have it established, and then have life insurance pay into it. So that's another kind of planning that we could talk about in another session, but special needs trust I wanted you to be aware of. Next slide. I think we covered this, so I'm going to move on. Okay, there's another trust for life insurance. Some people say I cannot, if I hold on to my $1 million life insurance policy that I have for my children, I don't want it to have to go through probate, so they separate their life insurance policy in a special trust. These are trusts that often are done for tax planning purposes, because they want the money not to be taxed in their estate, but they want it to be there for their heirs. There's a trust for your residence. You can create a trust just for your residence. So I don't want to put all my money in a trust, but I want to protect my house. So there are trusts specifically for houses. There are trusts that say, I want to put my money in a trust, but I want to make sure I get an income stream, because I really need that money, the interest income. And those are called graduated annuity trusts, where the trust is established and it has a set income amount that's paid out to the individual. We've often heard about pooled trusts. You may have heard about that in the Medicaid context. And those are trusts that are pooled with other people who have small amounts of money, and a charitable organization pulls the money into one big giant trust for planning purposes. And then people often put their excess income into a pooled trust when they have too much income that puts them over the income qualifier for Medicaid. They don't want to give away the income. They don't want to have to pay it to Medicaid. They need it for their health, but holding on to the income makes them ineligible for Medicaid. So they put their extra money in a pool trust that's managed for them by the charitable organization, and they have access to it to enhance their level of care needs. And then there's a trust that you're the grantor, you're the creator, you put your money in to protect it for asset protection purposes, but you still get the income and you still have all the tax responsibilities. So these are different kinds of trusts. And I guess I'm talking to you about them just for you to be aware that there's not one size fits all trust. Trusts are customized and developed for your needs because they function as wills, they function as management tools, and they function as often asset protection tools for future benefit needs. So these are, and that's why I wanted to show you the variety, so that you would know when an advisor says, the trust may cost you $5,000 to do, say, what do I need that for? Because it's a customized document just for you. Next slide, please. This is tax law, and I'm not sure how much, but I just wanted you to be aware of tax law, because some of you sit out there and say, oh, how do I avoid estate taxes? And you worry about it and you make all your estate planning around taxes. And I think for many of us, that boogeyman's never going to come to roost. So I want you to understand the tax rules. At the moment, if you die with a estate of under 12 million, you will pay zero, no estate tax. And in 2025, if the law that's on the books today sunsets, doesn't get reenacted, isn't reinstituted by Congress, then the ceiling will go down to 5,600,000, which in this day and age, in this probably is still a pretty generous ceiling. So estate tax in most of our cases is not the boogeyman it's made out to be. The other thing that we have now in our law is if you're married, and I am married and I have in New York State 5 million exemption, my spouse has 5 million, or 12 million and 12 million. If I die first and I didn't need 12 million, I only needed 2. I have an extra 10 million of this exemption. I can, it's portable. I can move it over to my spouse. And if he dies or she dies with a larger estate than I had, he can use their 12 million plus my leftover 10 million. So this exemption amount between spouses is portable. It can move back and forth, and therefore you really, as a couple, have close to $25 million to pass to the next generation without any tax. You and I, single people, don't have that portability, but couples do. The reason we worry about the estate tax, so it's a boogeyman, it's a real boogeyman, but it's only that because the tax rate today is 40%. So for every dollar that's over 12 million that I would try to pass to my heirs, before they could take it, they'd have to give 40% back to the tax man. The other thing is there's a gift tax exemption as well. So the government got smart and they unified estate tax and gift tax into one amount. So this 12 million I speak about is a unified gift and estate tax. So if I wanted to, I could use the whole 12 million exemption in life and gift. I could gift, if I had 6 houses, I could give them all away. And I would only use up maybe 6 million of my estate and I still in gifting. So it's a unified exemption amount that you can use in life or death. The federal government says when you gift, the first 17 million that you give away is exempt, and you can give 17 million, excuse me, did I say million? I apologize. The annual gift tax exemption, and it says 2018, but it's the 2023 number, is 17,000 a year. So every year I can give gift to anyone I wish, my children, my special friend, my banker, anyone I want, I can give $17,000 every single year. And if I wanted to give more, let's say my son said, Mom, I'm really trying to buy a house. I thank you for the 17, but I really need 25. I could give him 25. The first 17 would be exempt, and I would have to report to the federal government the excess. So, so the excess above that, the 8,000 above that, I would have to report, and Uncle Sam would say, okay, instead of having 12 million, Judy, when you die, you have 12 million minus the $8,000 you gave to your son in 2023. So if you wanted to give more than 17,000, excuse me, to anyone you wish, you will not pay taxes until you hit the $12 million ceiling. So I just wanted you to be aware of that now that we're sometimes being asked to pay for our kids' tuition or something, and it's more than 17, you can do it without worrying about paying taxes. You have to report it, and Uncle Sam keeps a tab on you. So the maximum gift exemption amount really is the same 12 million. A married couple can go up to that, the lifetime giving of double that. So federal gift and estate tax is unified. You can give it in life or death. And the only 17,000 is an exemption for not having to report. Anything above that must be reported. Okay, next slide. Next slide. Okay, so if you want to give straight to your grandchildren, you can, the same way you would give to. But if you give more, you're limited in life. You can only, if you pay more, give them more than the 12 million out to grandchildren and skip a generation, you will pay an additional tax. So keep your grandchildren gifts below, or give to the children first before you give to the grandchildren. This is called generation skipping tax. And the reason they do that is Uncle Sam's got to wait 2 generations instead of 1 to get his tax. So they put a limit on it. Okay, next. I have 2 questions in the chat that I'll stop and answer. One is, do you need to add social security number for beneficiaries? Often the financial institutions, especially if they're retirement accounts beneficiaries, they will ask for social security number because there's tax involved, but it's not required. And social security numbers do not have to be put into a will ever. Can your executor be out of state? Yes, your executor could be out of state. If they're not US citizens, though, that's when they have much stricter rules. We talked about portability, so we're going to skip this slide. Next. New York does have a state tax. That's why Mr. Trump moved to Florida, because they have no estate tax. Right now, the New York estate tax ceiling is 6.5 million. It will rise every year by subject to inflation. So we may see this number increase every year. And the maximum tax rate in New York State is 16%. So it's not a small tax. It's not 40% like the feds, but it's not a small tax. The next slide. New York has some special conditions that if you gift, New York has no gift tax, but they do have this clawback provision. So if I gave, that same $25,000 to my son for help him with his down payment on his house, New York would not ask me to do a gift tax return. But if I died within 3 years of that gift to my son, it would be clawed back and be counted as part of my estate. So just give, if you're going to give it often, give it early, because you want to avoid that clawback, that 3-year clawback. Next slide. What happens if you, I guess this repeats the same thing. Next slide. So people worry about this gift tax and how many gifts can I give in any year? So the number is 17,000 per year, and there's no number of limitation. You can give 30 gifts of $17,000, and you can next year can give the same 30 gifts of $17,000. As long as it's below 17, it's an invisible, non-reportable gift. If you go a dollar over, still New York State doesn't care about it because they don't have a gift tax, but the federal government will consider that and deduct from your unified exemption amount. Okay, next. So these are some tax terms that get thrown at you, and I just thought I would go over them. So transfer tax. When someone asked about, can I transfer my house to my son? And I will say that yes, you can, and there's no gift tax. There probably would be no gift tax because it's under the $12 million, but there may be some transfer tax that New York would impose on the filing of the deed. And it's about a 2% tax on the transfer amount. If it's a gift, again, there would be none. But if it's for pay, you would have to pay transfer tax. Portability between spouses just means that if you don't use your full exemption amount in your lifetime, it's portable and transferable to your surviving spouse. The annual gift exclusion amount is $17,000. And any consideration is considered a gift. So if I gave my son my house and he paid me $200,000 for my house and it really was worth $6 million, Uncle Sam would say it was part gift, part sale, and I would have to report that partial gift. The fair market value is what the world says is the value. What if you put it on the open market? What would be the fair market value? And some people ask about, well, is there a difference between a probate estate, a gross estate, a taxable estate? So the probate estate, as we talked about, only what goes through the court probate system. But the taxable estate or the gross estate is everything. Uncle Sam is going to tax everything, even those joint beneficiaries. So they count everything. To get up to that $12 million, they'll count your annuities. They'll count your 401ks. They'll count your house. They'll count the life insurance policy. Anything that you could have touched at your death is considered part of your taxable estate. Next slide. This is another tax that people worry about. It mainly relates to their home. I keep using myself as an example. I bought my home way back when I had my son, and I paid $80,000 for my house. And today, with inflation and gentrification and appreciation, my house is worth $1 million. So that increase in value from my original purchase price, or what the world calls cost basis, and the market value price, which is the $1 million, that growth, Uncle Sam says, when you sell it, Judy, I want a piece of that action. I want some of that growth or appreciation. And that can be pretty hefty, right? From 80,000 to $1 million. And the tax rate for capital gains happens to be 20%. And that may scare you. Say, Judy, I was counting on selling my house in Queens and retiring to, near my daughter in Pennsylvania, and I was going to use that money to live on it. Uncle Sam's going to take 20% of it? Maybe not. Because when you sell your personal residence, you get an exemption of $250,000. And if you have a spouse, he gets $250,000. So therefore you have a $500,000 exemption on your Queens house. And then you said, but Judy, I put in a new kitchen, I put new bathrooms in, I had a concrete wall, I put 3 boilers in since I've lived there. So all of those are capital improvements, which add to your cost basis. So in my case, my $80,000, when I did my 2 new bathrooms, and when I did the upstairs tenant's apartment, and when I did this, and when I did that, I added $250,000 in improvements. So now my cost basis is not $80,000, but $280,000 because I put 200 in improvements. Therefore, my cost basis plus my exemption, I might not pay so much capital gains. So that math calculation you should go through before you're frightened of selling your house because of that. Now, some of us depreciated our house over time. So we, every time we filed our taxes, we depreciated some of the cost basis. So we may have a much lower cost basis than we thought. So those are the kind of things that you should be aware of in selling your home. What is the capital gains implication? When a house passes at death, so if I was married and I own my house jointly with my spouse and the spouse dies, upon that spouse's death, that half interest that was the spouse's gets stepped up to date of death value. So my cost basis is still down here at 250, and that other half gets stepped up to date of death value. So if a property is inherited from someone at death, there's a step up in cost basis. So capital gains tax is a real calculation, and I don't want you to just fear it, but really try to understand it. It's based on your original purchase price, capital improvements, step up at death, and also any exemptions you might enjoy as your personal residence. That exemption is only for personal residence, and you have to have lived in the personal residence 2 out of the last 5 years to get the exemption. So people can flip a house every 2 years, move, and get that exemption again and again and again. But for you, for your personal residence, you have to have lived in it 2 of the last 5 years. Next slide. I guess these are some questions. We're going to just test our knowledge, and then I'm going to stop so you can, I've been answering the questions as we go along. But if I change the deed on my 750 house and give it to my children, Will it be subject to gift tax? And someone asked this question in the chat, and I said I would deal with it. So I'm going to give my house to my kids. I'm going to add them, or I'm going to add them to the title or whatever. First, before you do that, I want you to really think about your home. You're going to put in your kid's name. What happens when they die? What happens if they have disability? What happens if they have debts? Or what happens if they have divorce? So if you have two sons you're going to put on your house, and the two sons don't get along, you might have a landlord now who they're fighting with each other, and you need the boiler fixed. Or one of them gets divorced, and now that property is in a divorce settlement. Or one of them, God forbid, dies, and now that property is in the state, and your daughter-in-law is now your landlord, and you're not so sure about her. Or three children who now live, they're all trying to find themselves. So before you move a property out of your name into your children's name, I want you to ask questions about what would happen if they died, they became disabled, they had debts they didn't tell you about, or they got divorced. Think about a trust before you put it in your children's name. But will it be subject to gift tax? And the answer is yes. But in your case, you have a $12 million exemption, so you won't pay any taxes because you're just going to use up $750 of your exemption. But you do have to file a gift tax return. Next question. If my estate is $3 million in assets, will I have to pay estate taxes? Nope, because the federal exemption is 12 million and the state exemption is 5 million, so you don't have to pay estate taxes. Capital gains tax. If I sell my 750 house, will I pay a capital gains tax? Well, depends on what your cost basis is. If you paid $100,000 for it and you have a 250 exemption, now you have 300,000 exemption, you still have some gain. So you have to really do that calculation. And how do I get a step up in cost basis? Only way is if you inherited or received the house based on someone passing it to you at death. That's when the step up happens. Next slide, and I think we're going to end it here. Yes, keep going. Let's see if there's any. We talked about gifting quite a bit. I think we're at the end. So if you want to go to the thank you slide, I'm going to look at the questions. My healthcare process. Did I get everybody? Is this a will avoid probate or only a trust? I think we answered that, and a will is required to go through probate. A trust will avoid probate, or naming beneficiaries on everything. Our next question is, if your trust is in excess of 12 million and the trust buys a home for 2 million for one of the beneficiaries of the trust. So you take the 2 million out of the trust and you buy a home for someone else. Will there be a tax payment for the 2 million, even if it stays in the trust? So if the property stays in the trust, you as a trustee have just made a new investment strategy. Instead of sticking 2 million in a brokerage account, you're sticking 2 million in the purchase of a property, but the property is still owned by the trust. Nothing changes. It's really not a gift. It's a reinvestment strategy, and you may have changed the beneficiary to say at the end of the day, when this trust dissolves, and I don't know when that trust dissolves, maybe at the death of the grantor, that property is going to one specific beneficiary. If the total estate is in excess of 12 million, yes, someone's going to have to pay the estate tax on the trust, and whether it's coming out of the leftover residuary trust assets, because this house is frozen in bricks and mortar and going to a specific person, then the trust will have to pay it out of the residuary and the house will stay intact. But if it's still inside the trust, it's still taxed at death if it's over 12 million. Let's see if I got everybody else. And I'll look at the chat. I think I answered all the chat questions too. Madison, is there any other questions you want to bring forward?
No, ma'am. Thank you so much for the extremely informative information. I know it is a lot for everyone to process, So please, if you think of any other questions, do not hesitate to reach out to me. I'm happy to pass them along, and we will
And
certainly
my
do.
email address is here as well, and you feel free to write to me. And if you have, if you wish, either we can send you this PowerPoint, or Madison can send you the PowerPoint. I don't know if that's an offer you usually make, but we will make it.
Certainly, we are happy to do that. You're welcome to send it to me, and I will get it to everyone. And then just a reminder to everyone here today, next week, we'll be talking about wills, trust, and avoiding probate. So that'll be next Wednesday, also at 1 o'clock. So we hope you're all able to join us then.
Yeah, because we talked about this at, we just gave you a taste, and then the next sessions will dig in deeper on all of these topics. Thank you.
Great.
My
Thank you all
pleasure.
so much for being here. Thank you, Judith and Rachel. And I look forward to hopefully seeing you guys all again next week.
You bet.